This is Dish and Dirt with Gary Pickren, South Carolina's only podcast dedicated to the real estate agent craft. And now, the host of Dish and Dirt, Gary Pickren.
And greetings, welcome back, everyone, to another episode of Dish and Dirt. I'm your often opinionated but rarely wrong host, Gary Pickren, coming to you from the beautiful downtown Columbia, South Carolina offices of Blair, Cato, Pickren, Castelline. This, the third week of March 2025. So today we're going to talk about agency. We're going to talk about the purpose of agency rules, but mainly what we're going to talk about with agency is going to be the interference with agency. We've had several cases come before the Real Estate Commission in the last 6 months. A couple of them were very big cases that talk about the interference with agency and what is expected of a real estate agent in making sure that they do not interfere with agency. So we're going to get really into that. I've been doing a couple of legal tips over the last 5 or 6 weeks that cover this. We're going to try to compile it all into one and expand on a couple of those issues for you today. So before we begin today, we are going to give you a quick update on clear cooperation. As you know, over the last few weeks, we've talked about clear cooperation with a lot of leaders in the industry. But what's getting ready to happen now is NAR apparently is going to vote as to whether to keep clear cooperation in its current form, revise clear cooperation, or abandon clear cooperation. The good news is Coldwell Banker just came out and said they were supporting clear cooperation. They would be fine with some amendments to it, but they thought getting rid of clear cooperation overall would be a terrible thing for the industry. That's great news because now you have a large brokerage like Coldwell Banker with EXP, where these two big brokerages could stand to benefit from clear cooperation going away, because these two big agencies in a lot of towns would have a monopoly over a lot of the listings. And in order to get those listings, you would either have to work with an agent for those companies, or agents would have to quit their smaller brokerages and go work for those bigger brokerages if they could get rid of clear cooperation. It's great to see two of the leaders in the industry saying, even though we would financially benefit from this, we think that's bad policy. We think it's bad for the consumer. So no, we are not going to support getting rid of clear cooperation. On the other hand, we still have that asshole, Michael Ketchmark. He's the one who brought the lawsuit in the Sitzer Burnett case. Well, he now is saying that if clear cooperation doesn't go away, he's going to start deposing all the brokers at NAR who vote for it and go after them to try to find out their reasoning. Well, I don't know who died and made Michael Ketchmark the king of real estate. But once again, Michael Ketchmark is showing his complete ignorance, because there's many reasons not to get rid of clear cooperation. First and foremost is fair housing. Secondly, is it would eliminate competition. It would result in the Walmarting of the industry. Just like how Walmart comes into small towns and runs all the mom and pop stores out of business, the same thing would happen in real estate. The bigger brokerages would run the smaller brokerages out of town. So if you have your own brokerage or you work for a boutique brokerage, those would be gone in favor of the big brokers, of which two of them have just now come out and said they don't support it. They don't want it. But Ketchmark, who believes he has this infinite power to shape and change real estate, says he's going to do that. Interestingly, you have to have a lawsuit to depose somebody. I can't just decide as a lawyer, I don't like what you do, so I'm going to go call up a particular brokerage and say, I'm going to depose you because I don't like your policies. You actually have to have a lawsuit involved in that, a legitimate lawsuit. And somehow he's claiming that the Gibson case, which is part of the Sitzer Burnett, that whole entourage of cases there, somehow he's going to use that to do it. I fail to see how he's going to do it. I think he's just pounding his chest, but he really just needs to shut up and go away. I think everybody's sick of him. You got your $500 million of flesh out of the industry. Now take it and go buy an island somewhere in the Pacific and leave us alone. But that's what we've got going on. So I'll continue to update you on that and let you know the goods and the bad. We need to continue to stand up for clear cooperation, let NAR know that it cannot go away. We absolutely have to have clear cooperation for a fair market, a free market, and a market that supports fair housing. So don't let them talk you out of that. All right, now let's move into today's topic. Today's topic is all about agency. And what I want to do is kind of dispel some of the myths of agency, some of the things that agents get wrong, as well as look at some of the ways that agents could get in trouble. And a lot of time they may not even know that it's a violation. And what we're talking about is the interference of agency. There's a lot of times that agents are actually interfering with agency because that's how it's always been done, or that's how they were taught. And they're not realizing that that actual practice is in fact a violation under our law. So to begin today, I think we have to go back to the beginning and look at the whole purpose of the agency statute. Why do we have agency in our statute? And keep in mind, not all states do, and not all states are as vigorous in protecting agency as South Carolina is. South Carolina has statutory language that protects agency. But what is the purpose of protecting the agency? Is it to protect the real estate agent's business? Is it to protect their commissions? The answer to that is absolutely not. the statute 40-57 has very little in that entire statute about protecting real estate agents' business. It has almost nothing in there about commissions at all, much less protecting commission. Remember, the statute is drafted and was adopted to protect the consumer, to protect the public. So when you think about the fact that the real estate commission doesn't even have jurisdiction over commission disputes, why would the statute have anything to do with protecting your commission? In short, it doesn't. So the actual purpose of agency and the statutes prohibiting the interference with agency isn't to protect your business. It's not to protect your commission. In fact, what it is to do is to protect the consumer. Well, you're thinking, how does that protect a consumer? Well, it protects the consumer because once the consumer decides that they want to work with this agent to list a house or they want to work with this agent to help them buy a house, that it makes sure that the consumer is free of pressure, second guessing, conflicting advice, and so forth. Once I decide as a consumer that I want you to be my agent, I shouldn't have 6 or 7 other agents in here playing Monday morning quarterback telling me how they would have listed my house better, or they would help me find a house better, or that they could have gotten a better price for me, or this is how they would have done stuff. I need to be free of that pressure so that I can accept the advice that I'm giving by my agent that I chose. So once I make the choice as the consumer that I want you as my agent, I shouldn't have the pressure of other agents in my ear telling me what I should be doing or what I shouldn't be doing or all the things you're doing wrong. So you have to understand that the purpose of agency and the purpose of protecting agency is not about protecting your commissions at all. It's not that. It's all about protecting the consumer. So let's look at what the actual law says. In South Carolina, the law says you will not interfere with agency. It doesn't say you'll do your best, you'll ask a question, you can turn a blind eye, and as long as you don't know that you're interfering with agency, it's okay. As long as you don't know it, as long as you don't have actual knowledge that they've signed with an actual agent, you know who the agent is, you're okay. That doesn't say any of that. It says you won't interfere. So let's look at 40-57-710. This is the grounds for denial of issuance of license or for disciplinary actions against the licensee. And what it says under Section A, in addition to Section 40-1-110, the Commission may deny the issuance of a license to an applicant, or may take disciplinary action against a licensee who, and this is number 24, engages in a practice or takes action inconsistent with the agency relationship that other real estate licensees have established with their client. It's very clear. You will not act, practice, take any action whatsoever that is going to be inconsistent, i.e. interfere with somebody else's agent relationship. So if you have an agency relationship with a client, as an agent, I can't do anything to interfere with that. I can't do anything that's inconsistent with your rights as an agent and under an agency relationship. I can't do anything in my practice to interfere with that. And so you can see there that it's not this vague notion that it's okay to do it as long as you don't have actual notice or actual knowledge. I mean, it would have said that. You may not, unless you have actual knowledge, you may not interfere with. It doesn't say that. It says you will not do it. It's sacrosanct. So we've got to, as an industry, stop interfering with the agency agreements that other agents have with clients for the sole purpose of protecting the consumer, not to protect the other agent, to protect the consumer. And we need to start holding other agents accountable that do. So let's talk about what the commission has already held. The commission is held in hearings, and these hearings were of record. You got minutes on all of these. The commission has held that you have this affirmative duty, and it is not something that you should ignore. The commission has actually said that you have to do or take a good faith effort to ensure that you're not interfering with agency. That's the key there. Is there a good faith effort to ensure? And the commission has said simply asking a question and moving on is not a good faith effort. So, for example, if I was to meet with a consumer who I want to have a client relationship with, and I say, well, are you working with another agent? And they go, no. Okay, well, ask the question. I'm free. That is not a good faith effort. That is not even a modicum of an effort. That's basically laziness, and that's hoping that they say no so you don't have to go any further. Simply asking a question to a consumer, hoping you get the answer you like, and saying, well, I did that. I'm good to go. The reason behind the commission's opinion is that a lot of consumers don't understand the difference between consumer, customers, and clients. In fact, there's a lot of real estate agents that don't understand the difference between a consumer, a customer, or a client. There's agents that don't even understand how one becomes a customer or how one becomes a client. Sad as that sounds, but that's true. We know that to be a fact because we have to discipline these agents sometimes. But They also don't understand the difference in some of these words when you talk about working with or working for, being able to provide advice. And so the fact is, the consumer doesn't understand the difference between customer or client. They don't understand the difference in some of the terminology. So it's easy for the consumer to simply say, no, I don't think I am, when they don't understand. Secondly, we also know that we have a lot of paperwork that we now have to provide our consumers. For example, as a result of the Sitzer Burnett case, as well as the statutory requirements, the Real Estate Commission recently opined that the disclosure of brokerage relationship form has to be given before substantive contact. And the commission has defined as substantive contact is it happened before you showed a house. You can't show a house and not have a substantive contact. So early in this meeting with the consumer, you're going to provide this paperwork. For some, that might be in conjunction with doing agency. For others, this might be it. You might provide customer service at this point, and then later down the line might then go into client services, which means now you're providing more documents, you're providing more explanations. And so because of that, the consumer doesn't know the difference between what you talked with them about when you gave the disclosure versus what you talked about when they signed agency. And so they get confused as to that. We also know, and I know this is going to shock you, that sometimes our clients will literally lie to us. I know that is mind-blowing and shocking. But why do they do that? One is because they don't want to lose out. They might think that there is a house out there that's available, that if they can just get to the right agent, then they can get the house. And oftentimes that means they're going to call the sign. And so what can happen is you have a sign call and the person simply asks a quick question. Well, you're working with somebody? No. Again, the client doesn't understand. They've already got agency, and calling the agent on the sign should be a no-no. Clients lie because they also believe there's a secret stash of properties. They believe that there's a secret listing out there that nobody else knows about except this particular agent they met at a party or at a soccer game. We all know that not to be the case. The multiple listing service doesn't have a I get to get the listings first option. I can't pay an extra $1,000 and be the first one to hear the listings. The listings come out exactly at the same time for everybody. So everybody's getting the listings at the same time. So there's no benefit in that, but the consumers don't know that. So sometimes thinking that somebody they meet at a party might have a listing they don't know about. This also kind of goes to CCP, clear cooperation, and the fact of if we do get rid of clear cooperation, think of the agency problems we are going to have, because the lying will happen a lot more. Because if I'm working with you as a client and we can't find that house you like and we don't have clear cooperation, that means other agencies might have in-house listings. So of course my client's going to cheat on me and go call those other agents to see if by any chance they have a listing that they can get their hands on. So get rid of clear cooperation and you're going to have clients cheating on you left and right, and you're going to have a lot of bad blood between a lot of agents over procuring cause and interference with agency. So another reason we don't need that. But the bottom line is, here's what we're seeing without a shadow of a doubt, is there's many reasons that a consumer might not know and answer incorrectly to that simple question, or might know the answer and lie in answering those questions. So what the commission has said is that's not good enough just to ask a simple question. You're working with somebody. So it's more. Well, how will we understand what more is? Well, they're going to look at the totality of what you've done. Have you asked legitimate questions that will literally get you to the heart of the situation? Are you asking the probing questions necessary to determine whether or not you're interfering? Nobody's expecting you to pick up the phone and call every real estate agent in town, call all the brokers, send out an email, anybody working with this person. Nobody's saying you have to do that. So on the one hand, the extreme would be picking up the phone and calling every agent. On the other hand is simply asking a question saying, are you working with somebody? And they say no. Those are the two extremes. So somewhere in the middle, right? So what is it reasonable to do? And so what's going to happen is, if you had a grievance, you would have to come in and explain the totality of what you have asked. What have you done to make sure that you're not interfering? I was talking to Austin Smallwood today from SC Realtors, and he made a good point that perhaps it's time for the brokers to come up with a checklist. So when you meet with a buyer, you're asking these questions so that if they are in fact going to lie to you or not understand, now you have 6, 7, 8, 9 questions that you've asked them. They've had to lie or misunderstand 9 times. And that's certainly something you could show a grievance board or the Realtor Association if you had a grievance there and say, look, I asked these 9 questions. I can't help they lied to me 9 different ways. I took a reasonable effort to try to determine whether or not they had agency. So for example, how I would handle it, and this is how I usually teach it, is if I was working with a buyer and I wanted to have them sign agency, the first thing I'll probably say is, but what houses or what neighborhoods are you interested in? And they would say, well, I really like Spring Valley. I think it's a great neighborhood. I'd really like to look over there. So my next question is going to be, well, have you had the opportunity to look at any houses? If they say no, I haven't had a chance to get any houses yet because I don't have an agent. Well, that's good news right there. I'm getting to where I need to be, that they probably don't have an agent. On the other hand, if they say, yes, I've looked at 3 houses in that neighborhood, red flags, bells, and whistles should be going off, because what that is telling me without a shadow of a doubt is that they are, in fact, working with somebody. They did not get into 3 real estate properties without having an agent. Now, maybe they got into one because they went to an open house, and I could get a little bit more by asking those questions. But if they've been into 3 different houses in the same neighborhood, then perhaps they're working with an agent. If they said, well, I haven't been in any houses yet at all, I might ask them if any other neighborhoods they've had a chance to actually look at. And they say, well, I haven't been in Spring Valley, but I went into Kenwood and I did like Kenwood. I saw 2 or 3 houses in there. Okay, again, red flags are going off. Once they say they have seen other houses already and the red flags, the bells and the whistles start going off, then what you need to do is then ask more questions. Don't go, well, who are you working with? Don't do that. What you want to say is, great. What did you like about those houses? Where were the houses? Tell me a little bit about them. And then say, okay, well, what agent showed you those houses? I didn't ask them, did an agent show them? I'm asking a leading question, what agent or who showed you those houses? Because I already know an agent showed them the houses. I'm not giving them a way out. I'm not saying, well, did you have an agent? Because they'll be, oh, no, I didn't. No. What agent? Who showed you those houses? And then at that point, they're going to have to answer me, well, I saw those houses with Andy. Well, at this point, I have a duty, right? Because I've already said your duty is not to interfere with agency. So what at this point I'm going to do is say, well, look, I know Andy very well. He's a great agent. I'm required by law not to interfere with the agent of another licensee. So I need to step out real quick and call Andy to make sure that I'm not interfering with his agency agreement. Well, on a side note, that's actually good for you. You're going to try to get them to sign with you now under agency because Andy doesn't have agency. You now have taken the opportunity to prove that you're a trustworthy and honest agent. Remember, statistics show us, all the surveys show us that real estate agents, lawyers, and used car salesmen all rank at the bottom for the least trusted and least honest professions in most people's opinion. Well, you just showed them that you're honest. All you got to do is show a modicum of honesty and you will win the day. And here you showed them that you have this opportunity to work with them, but before you will agree to work with them, you got to go check with one of your competitors to see if your competitor's already working with them, because it's the honest thing to do and it's what the law requires. So if in fact they're not working with Andy, I guarantee you they're not going to sign with you because you're now the most honest agent. So now you've contacted Andy and we're trying to find out, does Andy have agency? Well, I'm going to call Andy up and say, Andy, I'm sitting here with this so-and-so person, and I'm about ready to sign them for agency, and they've answered some questions that make me think that you may have shown them some houses in Spring Valley. So I need to ask you some questions. If Andy won't answer the questions, or he refuses to answer the phone call or whatever, or you can't get him on the phone, you can always call his broker. The broker's supposed to know whether you have agency. Well, what I'm going to do is I'm going to ask Andy, is he working with these people? And if he says yes, well, Andy, do you have agency? If he says yes, I'm going to ask him when it expires. And then I'm going to say, Andy, I'm very sorry. I didn't know that you had an agency agreement with this consumer. I'm going to go ahead and back out. I'll let them know that I cannot talk to you anymore. You might want to call your client because they're trying to cheat on you. All right. Then I'm going to go back to the client or the consumer and say, I just talked to Andy. You, in fact, did sign agency with him. By law, I can't interfere with his agency. So unfortunately, I can't help you today. You're going to have to go back to Andy. Well, I don't like Andy. I want to fire Andy. How do I do that? I cannot tell you how to fire Andy. All I can do is direct you to Andy or direct you to the real estate broker, and they can talk to you, but I'm not allowed. All I can ask you is when your agency agreement ends. Andy told me it's 3 more months. I can talk to you in 3 months, right? Now, if Andy, on the other hand, comes back and says, I don't have agency, then what can I do? At that point, I can say, well, Andy, I'm going to sign them up. Please do not call them again. I'm going to do a 6-month agency agreement, so please do not call my client. Then I go back and I sign them up. And if Andy calls my client, then Andy's interfering with agency because he doesn't have it and I do. So that's how we want to handle this. You do have that affirmative duty. You need to ask those leading, probing questions to do what you can to ensure, and then make notes of it in your file. That's why I still think Austin's right, having your broker come up with some little checklist that you can check that you asked those questions and how they answered, so that 5 months down the line, Andy doesn't pop up and say, hey, I had agency and you interfered with it. You want to protect yourself now. Put it in your file. The bottom line here is that once that agency signed, whether you signed it or Andy had previously signed it, all agents have the affirmative duty not to interfere. So let's talk about some of the other areas that we are seeing agents interfering with agency. One of the big ways that we saw interference was when an agent leaves a brokerage. You need to understand that if you're working for ABC Realty and now you're deciding to go work for XYZ Realty, that's perfectly fine. You can quit one broker and go to the other. But all of the clients that you got when you were at ABC Realty, and they might be your friends, they could be your family member, they could be leads that you went out and got on your own. And you could say your broker doesn't even know who these people are, never talked to them, doesn't know a thing about them. It doesn't matter. The broker owns those clients. You don't have any clients. The broker has the clients through the brokerage. So when you leave an agency, it is interference to contact the broker's clients and ask them to go with you or to tell them how to terminate. Quite frankly, I think it's even probably interference to tell them you're leaving. I think you probably can get by on saying, I want to let you know I'm leaving ABC to go to XYZ. You need to talk to the broker about who the new agent is assigned to you. And I know that sucks because you're going to sit here and say, yeah, but that's my cousin I'm working for, or my best friend, or I met these people at a soccer game. They're mine. I did all the work. The broker didn't do anything. That's not how South Carolina law works. Broker owns the clients through the brokerage. When you leave a brokerage, you may not do anything to interfere with the agency agreements already established, which means you cannot try to ask these people to leave with you. You can't communicate with them about leaving with you. You can't teach them how to terminate it. And that's what a lot of these agents will do. They'll call up and say, I'm leaving ABC going to XYZ. Here's what you need to do to go with me. They have to call the broker. Now, what I would recommend is before you even get to that point is go have an honest conversation with your broker. Broker, I'm leaving your company. I'm going to XYZ. Make sure we do this the right way. Here's a list of all of the clients I'm working with. These are my buyers. These are my sellers. This is where we are in each one of the transactions, whether we're under contract, showing properties, whatever. I would like to have these clients go with me. Would you agree to let me take the clients? If they say, yeah, we agree, say, okay, broker, then I would like to do a joint email with you on the email saying that I am leaving the company, moving to XYZ. With your permission, I have been granted to reach out to them to let them know I'm more than happy to take you with me, or that you can stay with the broker. Please let us know by responding to this email. And that way, the broker's in the email and everything is copacetic. You're not interfering with agency. But if you try to do it on your own and send emails outside of the broker and talk to the people about leaving to go with you and telling them how they need to call the broker to terminate it, you are in fact violating agency. And we popped somebody pretty bad a couple of months ago on this. Another area that we see problems with is talking to represented clients. First and foremost, you have got to understand you cannot talk to the client belonging to another agent, period, ever. Don't do it. If you represent a buyer, you cannot go around the listing agent and talk directly to the seller. That is a violation of the agency relationship. Some of y'all do it. Please do not do that ever. Do not ever, ever, ever go around an agent to talk to a client. If you don't think the agent is submitting the offers to the buyer or to the seller, contact the broker in charge. But do not go around them and start talking to the client. That is a big time violation. That will get you big time in trouble. Also, if you notice that a listing is expiring or that a listing has been withdrawn, you should contact the agent first to see if they're still representing them, because there may be a reason they withdrew the listing. But do not just immediately start calling the clients, because you cannot call their clients and start pitching them to when their agency expires to come with you. That's a big no-no. You see that an agent that is working with me has another 3 weeks left on the agreement on my listing, and you start calling me saying, I could have sold your house when this listing expires. You need to call me. I'm going to do open houses. I'm going to take newspaper ads out. I'll do a TV ad, whatever it may be. You cannot do that. The only conversation you can have with me is confirming that my listing expires in 3 weeks. And then you can call me in 3 weeks, but you don't get to call me before the listing expires to try to pitch me as to your services. Again, I would not call the client. I would call the agent first. That's going to piss off a lot of people, because I know a lot of people that all you do is work expired listings. It has to be expired, not expiring. You can call all the expired listings you want if it's expired. You got to make sure that agency agreement's expired. But you cannot call expiring. Oh, it's going to expire in 3 weeks, so I'll go ahead and try to get in early and lay down the groundwork. That does not work. That also rings true for direct mail and email solicitation. If there's a house that has a for sale sign on it and you know that listing is about ready to end, you can't email them 3 or 4 weeks beforehand. about how you can list houses and all the great stuff that you can do. Now, you can do it as a general mailer. So if you mailed the whole neighborhood and they just happen to be a house that a listing is getting ready to expire, that's fine. But you can't directly target them and not the rest of the neighborhood. So if my house was for sale, 2 more weeks left on the listing, you can't email me a flyer, a newsletter, whatever, talking about how great you are at listing and selling houses, unless you're doing it for the overall area. If you're just doing a general mailer, then that's fine. But make sure that you understand the difference in there. Don't pitch to a consumer while there's an existing agency agreement. Now, let me talk briefly about builder agents. Contrary to a lot of popular belief, builder agents are under the same law, 4057, that everybody else is, including 4057, 710. Builder agents have to comply with the requirement not to interfere with agency. How am I seeing this happen? If a represented client comes to a model home and you start trying to sell that home to the represented client, that's a violation of agency. So as an agent sitting in a model home, you have to ask questions. You can't just let a consumer walk in and say, are you working with somebody? And they go, no. You've got to ask more questions than that. Just like I mentioned earlier in this podcast. So you just sitting in a model home, somebody comes in, you don't ask the question, or you just ask that one simple question, you're working with somebody, they say no. You sell the house and you try to get them under contract. You've interfered with the agency agreement of another agent. Even if you don't sign the contract, even if you just show them the house and try to talk them into buying the house and ask them questions about their finances and stuff, you are interfering with the agency of another agent. So don't do it. This idea of you having to register your clients with a builder is also garbage. They're my client. Your agent doesn't get to talk to my client except through me, period. So that's wrong. If I take a client to a builder's model home and the agent says, you leave them with me, I take it from here, bye-bye. And I've heard of builders doing that if I was to take my client to that builder, then the policy is I have to leave my client and leave. Absolutely not. That agent is interfering with my agency. That consumer has hired me to represent their interest. You're representing the builder's interest. I'm representing their interest. So you cannot require another agent leave their client with you as an agent and let them go on their way. That is absolutely interfering with agency. Another way to interfere with agency as a builder is prohibiting agents from participating in meetings. As an agent, you cannot tell them they cannot be at those meetings. And I have heard I heard from an agent today who said that when they took their client to meet with the builder, they had 2 chairs out for the client, even though they knew the agent was coming, and they made the agent kind of stand over there, and they took over the meeting. They cannot leave out the buyer's agent. Their buyer agent is allowed to participate in these meetings when the seller is represented by an agent. That agent is violating the interference rule. And then most importantly, is that agent representing the builder cannot call your client even after the contract signed, other than to provide them information. The house will be built this day, the closing's done this day. But they can't call them and start having conversations about loans, about whether they're being approved, down payments, earnest money, all that stuff. All that has to go through the buyer's agent. And I'm hearing more and more where they're bypassing the buyer's agents, having conversations with the seller. And even when the agent says, I must be included in all of these communications, they say, that's not our policy. You have to have your client forward you the emails. Wrong. You as a buyer's agent better not be emailing the buyer, period. Email the agent. Now, if that agent allows you to include the buyer on that, that's fine. We got to get out of this completely wrong idea that the law doesn't apply to builders agents. It 100% applies to builders agents. And it doesn't matter if your company has a policy that we're going to interfere with other agency. You don't get to interfere with the agency of another agent because your builder client tells you to, period. So builder agents, you need to have these conversations with your broker and say, I think we might be violating some laws here. Now, my last thing I want to talk about is procuring cause. And I talked with Austin about this today as well. One thing that's always annoyed me is this NAR concept with procuring cause, that agency doesn't matter. Who has agency doesn't matter. That's not the predetermining factor. As I told Austin today, the NAR statement that agency doesn't matter is a national statement. It doesn't take into account that South Carolina has very stringent rules on agency, as well as very stringent rules on interference with agency. And so that statement doesn't apply necessarily. And he agreed that if you are violating agency of another agent, you do not get to reap the benefits, meaning You cannot come into a procuring cause discussion saying, well, I'm procuring cause. They didn't have anything to do with this house, didn't see the house, didn't know anything of it. And we find out that the only reason you have the client is because you stole them from the other agent. You interfere with agency and you didn't do the necessary steps to insure. Now, obviously, if you signed agency and the other person has signed agency, other agent signed agency, and neither one of you knew about each other and you both were asking the questions and doing what you're supposed to, now we are getting into the issue of who had agency first doesn't really matter. Who was a procuring cause? But if I have agency and you don't, and you go out and procure the property, you do not get to claim I am the procuring cause. Remember, after Sitzer Burnett, you don't get compensated unless you have a signed compensation agreement. Without a compensation agreement signed in South Carolina, you cannot get compensated anyway. So the story's over. The argument's done. No signed compensation agreement, no procuring cause, period. But the bottom line here is you do not get to violate the law, come in with unclean hands, as the legal argument makes. Go under any law, any court would say you don't get to reap the benefits of breaking the law. You don't get to commit fraud and then go, well, I'm the one who has the money now, I get to keep it. Well, you got it because you committed fraud. Same thing here. You violated the law in agency. You don't get to keep the money from the procuring cause. So yes, it does matter. Agency does matter in this. My final thoughts are this is I've been hearing over the last couple of months of certain sectors of South Carolina, particularly down in some of the coastal areas, where agency just doesn't matter. Agents steal clients all the time. It just happens. You win some, you lose some. You just got to get over it. Wrong. Do not interfere with agency, period. The Real Estate Commission, as you can tell from these hearings recently, very serious about protecting agency. So make sure that everyone's following the agency. If you're a broker, regardless where you are, you can be brought in for failure to supervise if you are allowing your agents to interfere with agency. So do not interfere. Do not allow your agents to interfere. And if you're a victim of it, start turning other agents in. We're never going to stop agents who constantly violate agency rules and interfere with agency unless they're held accountable. So that's our show for today. I hope everybody got something out of it. I appreciate you for listening to Dish and Dirt. If you'll please like us, share us, and subscribe to us, and come again next week for another episode. Y'all take care and have a great week.